My brother-in-law patented my late husband's invention as his own. 4 months after my husband died, I found his invention listed on a newly granted patent with someone else's name in the inventor field, and that someone else was my husband's own brother. My husband Anders was a mechanical engineer who spent nearly every evening of the last 3 years of his life in our garage, working on a design he'd become genuinely obsessed with. A modular irrigation valve system for small-scale farms, cheaper and considerably more durable than anything currently on the market. The kind of unglamorous but genuinely useful innovation that wouldn't make headlines, but could meaningfully reduce water waste and equipment costs for exactly the kind of small, struggling agricultural operations that couldn't afford the expensive commercial systems larger farms used. He wasn't chasing wealth with it, not really, though he certainly hoped it might eventually generate enough licensing income to let him leave his day job at a mid-sized manufacturing firm and work on engineering projects he actually cared about full-time. Mostly, he just loved the problem itself, the specific patient satisfaction of iterating through prototype after prototype until something finally worked the way he'd envisioned it in his head. I have a specific memory of one particular evening, maybe a year and a half before Anders got sick, when he came inside from the garage well past midnight, grinning in a way I hadn't seen from him in weeks, and pulled me out of bed to show me a prototype valve that had finally, after nearly a dozen failed iterations, sealed correctly under the pressure conditions he'd been struggling to solve for months. He explained the fix to me in detail I only partially understood, something about the specific angle of a rubber gasket relative to the valve housing, and I remember him saying, almost giddy, that this was the moment, that everything before it had just been getting the design wrong in slightly different ways, and this was finally getting it right. He wrote the date and the specific fix in his notebook right there at the kitchen table before he'd even let himself go back to bed. Said he never trusted himself to remember a breakthrough as clearly the next morning as he could describe it in the actual moment it happened. Anders kept meticulous documentation of the entire development process, the way careful engineers often do, both because good habits and because he understood, even before any of what happened later, that inventorship disputes were common enough in his field that a thorough paper trail was simply responsible practice. He kept dated design notebooks, photographs of every prototype iteration, email correspondence with a materials supplier who'd helped him source a specific polymer component, and detailed notes on every design failure and revision that had led, eventually, to a working prototype he was genuinely proud of. His younger brother Roderick worked in a tangentially related field, patent law specifically, though at a large firm that primarily handled corporate pharmaceutical patents rather than anything close to Anders's mechanical engineering work. The two of them had always been close, closer than many siblings managed to stay into adulthood, and Roderick had, over the years Anders worked on the irrigation system, offered informal advice more than once about the patent filing process, explaining terminology, answering questions Anders had about how provisional applications worked, the kind of casual professional favor you'd expect between brothers who genuinely liked and trusted each other. Anders was diagnosed with an aggressive form of leukemia just over a year before he died, a diagnosis that arrived, as these things so often do, without much warning, and progressed faster than any of us were prepared for despite every treatment his medical team attempted. In his final months, weakened considerably by both the disease and the treatment, he grew increasingly focused on making sure the irrigation valve project wouldn't simply die with him, wouldn't become one more unfinished thing among the many unfinished things a sudden terminal diagnosis leaves scattered across a life. He asked Roderick, specifically, to help him formally file the full utility patent application before he ran out of time and capacity to manage the process himself, trusting his brother's professional expertise the same easy, unquestioning way he'd trusted him with everything else over their entire lives. I want to be honest about something that matters to understanding what happened, the same way it's mattered in every account I've come to understand others have lived through something structurally similar. This isn't a story about a brother who was calculating from the very beginning. Roderick visited Anders regularly during those final months, genuinely engaged with the technical details of the invention in ways that seemed to come from real interest and real care rather than any calculated motive. He cried, visibly and I believe genuinely, at the funeral, spoke movingly about his brother's specific, quiet brilliance, the patient way he approached every problem he ever tackled. Whatever came later, I don't believe those final months of apparent collaboration were built entirely on deception from the start. Anders died in early autumn, 11 months after his diagnosis, with the full patent application still, as far as I understood at the time, in the process of being formally filed, a task Roderick had told both Anders and me he was actively managing on our behalf given his professional expertise in exactly this kind of filing. I trusted that explanation completely in the exhausting, grief-fogged months that followed, focused entirely on settling the rest of the estate, managing my own overwhelming loss, and simply assuming that the patent process, like so many bureaucratic processes involving a deceased person's affairs, was simply moving slowly through channels I didn't fully understand and had no particular reason to scrutinize closely. It was 4 months after the funeral, doing a routine online search of Anders's name, partly out of a quiet, grief-driven impulse to see what still existed of him online, that I found the granted patent listing, not a pending application, but a fully granted utility patent for a modular agricultural agricultural irrigation valve system, filed 3 months after Anders's death, listing Roderick as the sole named inventor. I'd been sitting at the kitchen table that evening, 4 months into a grief that still ambushed me at unpredictable moments, scrolling through old photos on my phone before deciding, almost on impulse, to search his name online, curious what still existed of him out there in the world, some small aching hope of finding an old forum post or a conference presentation I hadn't seen before, some fragment of him still circulating that I could hold on to for a few minutes. Instead, 3 results down, I found the patent listing. I stared at that patent listing for a long time before I could make myself fully process what I was looking at. The invention's technical description matched Anders's design precisely, down to specific details I recognized from countless evenings sitting with him in the garage while he explained his latest revision to me, details he'd been genuinely excited to share even though I understood only a fraction of the engineering involved. The application had been filed exactly 3 months after his death, using, according to the patent's public filing history, provisional application materials that had originally been submitted, I would later learn through careful research, nearly 18 months earlier under Anders's own name as sole inventor, before being formally converted to the full utility application under Roderick's name alone. I called Roderick immediately, my voice shaking, and asked him to explain what I was looking at. There was a pause on the line, longer than felt natural, before he answered. He explained, in a careful, measured tone I'd never heard him use with me before, that the invention had, in his account, been a genuine collaboration between the two brothers all along, that Anders had specifically wanted him listed as an inventor, given his own contributions to the design's development, contributions Roderick described somewhat vaguely as conceptual input and problem-solving conversations the two brothers had shared throughout the development process. He said that once Anders's condition worsened toward the end, they'd discussed informally that it might make practical sense for Roderick to take over the application process entirely, including inventorship, given how much technical patent expertise the filing actually required and how limited Anders's own remaining capacity had become. I asked him directly whether Anders had ever told him explicitly that he wanted his own name removed from the patent entirely, replaced solely by Roderick's. He hesitated longer this time before saying that the conversations had been somewhat informal, that Anders's condition in his final weeks had made precise, detailed conversations increasingly difficult, and that he'd used his own professional judgment to interpret what he believed Anders's genuine wishes had been, given everything they'd discussed together over the years the invention was being developed. I didn't fully believe that explanation, even as he was delivering it, mostly because of a detail that kept nagging at me the entire time he spoke. I had been present for the overwhelming majority of Anders's final months, had sat with him through most of his lucid conversations and most of his difficult, exhausted ones, and I had never once heard him express any intention to remove his own name from an invention he'd spent 3 years of patient, obsessive work developing. If anything, I remembered clearly, more than once, his specific worry about making sure the patent got filed properly, so that his name would be permanently attached to something he was genuinely proud of, a legacy he wanted to leave behind regardless of what else the illness took from him. The weeks that followed were a slow, sickening unraveling of a trust I genuinely believed, right up until that phone call, was built on real brotherly loyalty and real professional support during an impossibly difficult time. I requested access to Anders's original design notebooks and development files, which I still had in storage from clearing out our garage, and began going through them carefully, methodically, cross-referencing every dated entry against the patent's technical claims and against whatever timeline Roderick had described to me about their supposed collaboration. I spent an entire weekend pulling those boxes out of storage and spreading the notebooks across our dining room table, working through them chronologically, a task that felt, at different moments, like both an investigation and a strange private form of grieving I hadn't expected, reading his handwriting again after months of trying not to look at it too closely, seeing his specific way of sketching a cross-section diagram, the small, impatient exclamation points he'd sometimes scrawl next to, a breakthrough. More than once I had to stop entirely, close a notebook, and just sit with the specific ache of missing him before I could make myself keep working through the evidence. What I found, the deeper I went, was a paper trail that told a story almost entirely at odds with Roderick's account. Anders's notebooks documented the invention's entire development arc across nearly 3 years, with dated entries showing every significant design breakthrough, every prototype failure, every material substitution that eventually led to the working design. And in all of it, across hundreds of pages spanning years, Roderick's name appeared only a handful of times, always in the context of brief, informal conversations about patent filing logistics, never once in connection with any actual, technical or conceptual contribution to the invention's design itself. I brought everything I'd found to a friend of ours, sitting across her own kitchen table, the way I'd once sat across Roderick's, a mechanical engineer named Odali Ferrand, who'd worked alongside Anders at his manufacturing firm for years, and had, on several occasions, discussed the irrigation valve project with him directly, understanding its technical details well enough to have genuine, informed opinions about its design. Odali listened to the whole account with growing, visible alarm, and confirmed something that mattered enormously to what I was starting to understand had actually happened. Anders had discussed the project with her extensively repeatedly over the years, including several conversations where he'd specifically mentioned working through difficult design problems entirely on his own, without any input from Roderick beyond the patent logistics conversations I'd already found evidence of in his notebooks. He never once mentioned Roderick contributing anything technical, O'Daly told me. I remember him being almost a little amused by how little his brother actually understood about the mechanical engineering side of things, despite Roderick's genuine enthusiasm for the project as a family matter. He used to joke that Roderick's real contribution was just being excited about it, not actually helping design it. O'Daly suggested I needed someone with actual patent law expertise, independent from Roderick and his firm, to properly examine the inventorship question, since patent law, she explained, had specific technical legal standards for what actually constituted inventorship that went beyond simple enthusiasm or informal conversation, standards I didn't understand well enough myself to evaluate what I was looking at with any real confidence. I reached out to an intellectual property attorney recommended by a family friend, a precise, formidable woman named Cordelia Ashgrove, who specialized specifically in patent inventorship disputes. A corner of IP law, she told us, at our first meeting, generated more bitter, complicated litigation than most people outside the field ever realized, precisely because inventorship carried both financial and deeply personal stakes that made these disputes considerably harder to resolve amicably than most other kinds of patent disagreement. Cordelia's first move was requesting the complete patent prosecution history from the Patent Office's public records, including every document filed throughout the application process, to establish exactly how the application had evolved from its original provisional filing under Anders's name to its final granted form under Roderick's alone. This history, once fully assembled, revealed something Cordelia described as deeply unusual and legally significant. The original provisional application, filed nearly 18 months before Anders's death, listed him as sole inventor, with technical claims matching, in substance, what would eventually become the granted patent. The formal utility application, filed 3 months after his death, retained almost all of those same technical claims virtually unchanged, but listed Roderick as sole inventor, with a formal inventorship declaration Roderick had signed himself, asserting under penalty of perjury that he was the true and sole original inventor of the claimed invention. This is the piece that matters most, Cordelia told me, laying the documents out across her office table. Patent law requires that the inventor named on an application actually be the person who conceived the claimed invention, not someone who helped file the paperwork, not someone who provided general encouragement or informal conversation, but the person who actually came up with the specific, patentable technical solution. Your husband's own original provisional filing, made while he was alive and by his own account, already establishes him as the person who conceived this invention. For your brother-in-law to then file a formal declaration claiming sole inventorship himself after your husband's death is a serious legal problem, potentially fraud on the Patent Office, which carries real consequences, both civil and in some cases criminal, separate entirely from whatever family dispute exists underneath it. I asked her, once she'd finished laying out the initial legal picture, how common this kind of dispute actually was, whether I was looking at some rare, unusual betrayal, or something the patent bar quietly dealt with more often than outsiders realized. She was quiet for a moment before answering, choosing her words carefully. More common than it should be, she said. Inventorship carries real financial stakes, and death or serious illness creates exactly the kind of window where a family member with technical or legal access can insert themselves without much immediate scrutiny. Most cases like this never get caught at all, honestly. You happen to have a husband careful enough to leave a paper trail, and you happen to be persistent enough to actually look closely once something felt wrong. Both of those things matter more than people realize. Cordelia mentioned to me, near the end of one of our early meetings, that something about the ease and confidence with which Roderick had constructed his account, the vague language about conceptual contribution, the practiced professional-sounding justification, struck her as familiar in a way she couldn't yet place, a pattern she said she'd learned, over years of handling inventorship disputes, to trust as worth investigating even before she had any concrete reason to suspect it pointed somewhere specific. Cordelia's deeper investigation into Roderick's own professional history, conducted over the following weeks as part of building the full case, uncovered something that widened the scope of what we were dealing with considerably beyond a single, isolated act of opportunistic deception. She found, through a careful search of patent office records and professional disciplinary filings, a formal complaint filed against Roderick nearly 6 years earlier by a former client of his firm, a complaint that had been quietly resolved through the firm's internal process rather than ever becoming a matter of public disciplinary record. But that had left enough of a paper trail in adjacent court filings for Cordelia to piece together the basic outline of what had happened. That earlier complaint involved a small startup founder, a woman named Perpetua Achebe, who had hired Roderick's firm to help patent a medical device innovation she'd developed largely on her own. According to the complaint, Roderick, working as the associate attorney assigned to her case, had gradually inserted himself into the application process in ways that eventually resulted in an amended filing listing him as a co-inventor alongside Perpetua, based on what he'd described, in his own defense at the time, as substantial conceptual contributions claims made during their working sessions together. Contributions Perpetua had disputed entirely, insisting Roderick's role had been purely legal and administrative, never technical or conceptual. Cordelia spent nearly 2 weeks tracking down that old complaint, working through adjacent court filings and professional licensing board records since the matter itself had never become a formal public disciplinary case. She found it eventually, buried as a passing reference in an unrelated filing that happened to mention the earlier dispute by name, the kind of thin, easily missed thread that only surfaces when someone is specifically, patiently looking for exactly this pattern. Cordelia tracked down Perpetua through the old complaint's contact information, and I called her myself, nervous in a way that felt strange given I'd never met the woman and had no direct relationship to her case beyond the unsettling coincidence Cordelia had surfaced. She was cautious at first, understandably wary of a stranger calling about a painful, years-old professional dispute she'd mostly stopped discussing after it settled. But once I explained the situation, a deceased husband's invention, a brother's sole inventorship claim filed after death, a pattern of inserting himself into inventorship despite what appeared to be no genuine technical contribution, something in her tone shifted. The particular shift of someone finally, after years of quiet self-doubt, hearing confirmation that what she'd suspected all along about a pattern, rather than an isolated incident, had actually been real. I always believed what happened with my patent wasn't an accident, Perpetua told me. Everyone at the firm told me it was a reasonable professional disagreement about the boundaries of conceptual contribution, that these things happened sometimes in genuinely collaborative attorney-client relationships. I settled because fighting felt more exhausting than it was worth at the time, and because I'd started to doubt my own memory of how much input he'd actually provided versus how much he simply absorbed from listening to me explain my own work in detail during our meetings. I never fully stopped believing it, though. I just stopped saying it out loud after a while. I asked her carefully, listening closely to every word she chose, whether the specific pattern, inserting himself into inventorship of a genuinely significant, valuable invention that wasn't originally his, using vague claims about conceptual contribution to justify it, matched exactly what I was now describing to her about Anders's own case. She was quiet for a moment before answering. It's the exact same story, she said. Different invention, different relationship to the actual inventor, but the exact same method. Vague claims about contribution that sound reasonable in isolation, but that, when you actually try to pin down specifics, dissolve into nothing concrete at all. Perpetua agreed without hesitation to provide a formal statement describing her own experience for use in our case. Understanding, she said, that even though her own dispute had long since settled and couldn't itself be reopened, her account might still matter in helping establish that this wasn't a single, uncharacteristic lapse during an unusually difficult family circumstance, but a demonstrated, repeating pattern of professional behavior spanning at least 6 years and 2 entirely separate, unrelated inventors. With Anders's original notebooks establishing his sole conceptual development of the invention, Odele's corroborating account of his own descriptions of the project, the patent prosecution history showing the suspicious timeline of the inventorship change, and Perpetua's account of a strikingly similar prior pattern, Cordelia brought in a technical expert witness, a mechanical engineer named Basil Renner, with specific experience serving as an expert in patent inventorship disputes, to formally review Anders's development notebooks against the granted patent's technical claims and render an independent professional opinion on who had actually conceived the claimed invention. Basil worked out of a small consulting practice that specialized almost entirely in expert witness testimony for exactly this kind of technical dispute, and he explained his process to me carefully before he began, told us that a proper inventorship analysis meant reconstructing the actual conceptual history of an invention, rather than simply accepting either party's account at face value, cross-referencing every claim in the granted patent against the documented development record until each element either traced clearly to a specific point of origin or remained genuinely ambiguous. Basil's analysis, completed over nearly 3 weeks of careful technical review, was unambiguous in a way that left little room for Roderick's account to survive serious scrutiny. Every significant inventive element of the granted patent's claims, Basil concluded, could be traced directly to specific, dated entries in Anders's own notebooks, entries that predated any documented involvement from Roderick by months, or, in several cases, years. The notebooks showed a clear, continuous arc of independent problem-solving, failed prototypes, material substitutions, design revisions, entirely consistent with a single inventor working through a difficult technical problem alone, with no gap or discontinuity anywhere that might suggest a second person's genuine conceptual contribution had entered the process at any point. I want to be direct about what my analysis shows, Basil wrote in his formal report. Based on the documentary evidence available, there is no technical basis in the historical record for crediting anyone other than Anders Vasquez as the sole conceiver of the patented invention. The notebooks demonstrate a complete, internally consistent record of independent development. Nothing in this record suggests any second inventor contributed to the claimed subject matter at any stage. Cordelia's strategy, once Basil's report was complete, involved formally notifying the patent office of the inventorship dispute, dispute, a process that could result in a formal correction of inventorship if the evidence was found sufficiently compelling, alongside a separate civil claim against Roderick for the value of any licensing income the patent might eventually generate, since a corrected patent listing Anders as sole inventor would mean his estate, rather than Roderick personally, held the rights to whatever commercial value the invention ultimately produced. Patent offices take inventorship fraud seriously, but they also move carefully, since correcting inventorship after a patent has already been granted requires clear, compelling evidence rather than just competing family accounts, Cordelia told me. What we have here, your husband's own dated notebooks, an independent technical expert's confirmation, and a documented pattern from an entirely separate, unrelated case, is about as strong a record as I've seen in a dispute like this. Most attorneys facing evidence this thorough would advise their client to settle rather than risk a formal fraud finding that could affect his own professional standing far beyond just this one patent. We filed the formal inventorship correction petition and sent a parallel demand letter to Roderick's own attorney, laying out the complete case. I didn't hear anything for nearly 3 weeks, an anxious, exhausting stretch of checking my email obsessively, replaying every possible way this could still go badly despite everything we'd assembled. It was Cordelia who finally called, on a gray Thursday afternoon, to tell me Roderick's attorney had reached out requesting a settlement conversation. Cordelia spent the evening before that meeting walking me through what to expect, the same careful preparation I imagined she offered every client walking into a room with a family member who'd betrayed them this thoroughly. She told me my role wasn't to relitigate a lifetime of brotherly closeness on my late husband's behalf in front of 2 attorneys, wasn't to make Roderick feel the full weight of what he'd done in that specific room. It was simply to let the documentation speak, to be present and composed, while Anders's own notebooks and Basil's technical analysis and Perpetua's corroborating account did the work I couldn't do as convincingly through raw emotion alone. The settlement meeting happened at Cordelia's office nearly 5 months after our father's, my husband's, funeral. I still catch myself making that specific slip sometimes, months later, grief rearranging language in ways I don't fully control. Roderick arriving with his attorney, a younger woman who looked throughout most of the meeting increasingly uncomfortable as the full scope of the evidence became clear, the specific discomfort of someone realizing partway through a case that her client's version of events bears little resemblance to what actually happened. I hadn't seen Roderick in person since our tense phone call months earlier, and I found myself watching him settle into his chair across the conference table, struck by how much older he looked, how much thinner, the particular toll of carrying a secret this large for the better part of a year, visible in ways that made some small, stubborn part of me feel a flicker of unwanted grief even amid everything else I was feeling in that moment. Grief not just for Anders, but for the brother-in-law I'd genuinely trusted and cared about for over a decade. Cordelia walked through the case methodically, Anders's own notebooks establishing continuous, independent development spanning nearly 3 years, Odalie's corroborating account of his own descriptions of the project, Basil's technical analysis finding no evidence of any second inventor's contribution anywhere in the record, and finally, Perpetua's account of the strikingly similar pattern from 6 years earlier involving an entirely different, unrelated inventor. I watched something shift in Roderick's expression at that final piece specifically, a flicker of genuine shock that told me he hadn't expected that older, quietly settled case to ever resurface in a room concerning his own brother's invention. It was Roderick himself, not his attorney, who finally spoke, in a voice that had lost almost all of the careful, measured composure he'd maintained through our earlier, tenser exchanges. He said watching his brother die had left him with a specific, complicated grief he'd never fully processed, a desperate need to hold on to some tangible piece of Anders that felt, in his own confused reasoning at the time, like it justified attaching his own name to the invention, rather than simply managing its patent filing on the estate's behalf the way he should have. He said some part of him had convinced himself that being listed as an inventor was a way of honoring the brother's closeness, rather than erasing Anders's actual, sole authorship of the work. I told myself I deserved some claim to it because I'd been there for every conversation about it. Every late night he called me excited about some breakthrough, he said, quieter now. I don't know anymore whether I actually believed that gave me real inventorship, or just needed to believe it to justify what I was doing while I was doing it. He didn't address Perpetua's case directly, didn't offer any explanation connecting the two situations beyond his visible shock at hearing it mentioned, and Cordelia didn't press him on it in that meeting, telling me afterward that establishing a direct link between the two cases wasn't necessary to resolve our own, however much I remained curious about it. The settlement Cordelia negotiated over the following weeks required Roderick to formally cooperate with correcting the patent's inventorship record, removing himself entirely and naming Anders as sole inventor, with the patent rights themselves transferring, as a legal consequence of that correction, to Anders's estate and therefore to me as his sole heir. It also required Roderick to sign over any licensing negotiations he'd already begun pursuing in the months since the patent's grant, several of which, it turned out, once Cordelia's discovery process uncovered them, had already generated preliminary interest from 2 agricultural equipment manufacturers. Interest Roderick had been quietly cultivating under his own name in the months since the fraudulent patent granted. The question of whether to pursue a formal fraud referral against Roderick beyond the civil correction and settlement became its own own difficult extended conversation, one I worked through slowly, mostly with Odalie's steady support since I no longer had the sibling-in-law relationship with Roderick I might once have leaned on for exactly this kind of difficult family decision. Odalie sat with me through several long evenings that fall, not pushing me toward either decision, just listening while I talked through the same circling arguments more than once, letting me arrive at my own answer in my own time rather than offering one for me. I found myself torn between genuine anger at what he'd done, filing a sworn false inventorship declaration with the patent office, quietly building licensing relationships around a stolen invention while I grieved, unaware, 4 months into losing my husband, and a complicated, lingering grief for the version of him who'd sat with Anders through so many of his final hardest weeks, who'd seemed, at the time, like exactly the kind of family support I desperately needed during those months. I ultimately decided, after weeks of difficult circling deliberation, to let the civil correction and settlement stand as the primary resolution, declining to pursue a separate fraud referral to the patent office's own investigative body, though Cordelia made clear the full evidentiary file, including Perpetua's corroborating account, would remain available should any future situation ever require it. I had the corrected certificate framed, eventually, and hung it in what used to be our garage, now converted into a small home office, in the exact spot where Anders used to keep a corkboard covered in sketches and material samples during the years he worked on the invention. I stand in front of it sometimes, on quiet evenings, the way I imagine other people visit a grave, and I let myself feel, for a few minutes, the specific, complicated mixture of pride and grief and lingering anger that I don't think will ever fully resolve into something simpler. The corrected patent, listing Anders as sole inventor with the rights now held by his estate, was formally issued roughly 3 months after the settlement meeting. I remember the specific, strange weight of receiving that updated patent certificate in the mail, holding a document that finally, properly credited my husband for 3 years of patient, obsessive work he'd never gotten to see fully recognized while he was alive. I cried reading it, the specific kind of crying that comes from a grief that had briefly, terribly, been compounded by betrayal, finally getting some measure of real correction. I met the fund's first recipient, a quiet, determined engineering student named Wilhelmina Suarez, at a small campus reception 2 years after the fund's launch, and she told me, a little shyly, that she'd chosen her senior design project specifically because she'd read about Anders's irrigation valve system in the scholarship's founding materials, and had found herself genuinely fascinated by the specific kind of unglamorous practical engineering problem it represented. Not flashy, not the kind of project that would ever make her famous, just quietly, meaningfully useful to people who needed exactly that kind of useful thing. I didn't tell her, standing there listening to her describe her own project with the same patient enthusiasm I remembered from Anders explaining his prototypes to me in the garage, how much that specific description meant to me, how completely it echoed the exact quality in him I missed most. I pursued the licensing conversations myself over the following year, working with a licensing consultant Cordelia recommended, someone with actual agricultural equipment industry experience who could evaluate the manufacturer's interest properly and negotiate terms that reflected the invention's genuine value rather than whatever quiet, informal arrangement Roderick might have eventually settled for on his own. One of the two manufacturers who'd shown initial interest ultimately signed a licensing agreement roughly 14 months after Anders's death, a modest but genuinely meaningful royalty arrangement that has, in the years since, generated income I've used partly to establish a small scholarship fund at Anders's alma mater, specifically for mechanical engineering students working on agricultural or resource efficiency projects, the kind of unglamorous, genuinely useful engineering work he'd spent his own career quietly devoted to. Perpetua and I still exchange messages occasionally, two women who found each other through an unlikely, unsettling coincidence, and ended up, somehow, glad to have found each other anyway, the way I've come to understand strangers sometimes do after surviving a strikingly similar betrayal from entirely different corners of each other's lives. She told me once that hearing our case resolve successfully, with far more thorough documentary evidence than her own case had ever managed to assemble at the time, brought up a complicated mix of feelings she hadn't fully anticipated, genuine happiness for me, alongside a fresh, sharp awareness of exactly how much more her own case might have achieved if the same level of independent technical and forensic expertise had been available to her 6 years earlier. I don't regret the settlement I accepted, she told me. It felt like the right decision given what I actually had to work with at the time. But it's strange, watching your case unfold with all the tools mine was missing, understanding how much of what actually protects an inventor in situations like ours comes down to luck as much as anything. Who happens to keep detailed notebooks? Who happens to find the right technical expert? Who happens to notice a detail in time? I asked her, the way I imagine anyone in my position would eventually ask, whether learning about the connection between our cases had changed anything for her, whether it offered any real closure after all these years. She was quiet for a long moment before answering, and told me she'd mostly made peace with not being able to reopen her own case, that some mysteries and injustices simply had to be lived with rather than fully corrected, but that she found a genuine, if complicated, comfort in knowing her own experience had eventually contributed, indirectly, to stopping the same pattern from succeeding fully against someone else. He called on a Sunday evening unexpectedly, and I almost didn't answer, staring at his name on my phone screen for several rings before finally picking up, uncertain whether I actually wanted to hear whatever he'd called to say. His voice, when I finally answered, sounded smaller than I remembered it. None of the careful, professional composure he'd carried through our earlier exchanges. Roderick and I have spoken only once since that settlement meeting, that brief, strained phone call several months later where he apologized again, more directly this time, without his attorney present to shape his language into something more legally careful. He told me he'd left his firm shortly after the settlement, that the patent office's routine correction filing had, despite our decision not to pursue a formal fraud referral ourselves, still generated enough internal scrutiny at his firm to make his position there increasingly untenable once colleagues began quietly asking questions. He said he was working now in a different area of law entirely, something unrelated to patent prosecution, trying, in his words, to understand how a person convinces himself that grief justifies theft rather than recognizing it for exactly what it actually was the entire time. I didn't have much to say back to him in that call beyond acknowledging that I'd heard him, that I appreciated him at least attempting real accountability rather than continuing to hide behind the vague, sympathetic framing he'd offered in our settlement meeting. I don't know yet what our relationship will look like going forward, whether the family holidays and gatherings that used to naturally include both of us will ever find a way to include him again, or whether this particular fracture will simply remain permanent. One more loss layered on top of the original one that started everything. I keep those notebooks properly archived now, in acid-free boxes a conservator friend of Odalie's helped me source, along with copies of the corrected patent, Basil's technical report, Perpetua's statement, and the full settlement documentation, stored in a small fireproof cabinet in what used to be our shared home office. I don't open them often, but I want them there, the whole record, should anyone ever need to understand exactly how a careful patient engineer's own habit of thorough documentation ended up mattering more than he could have possibly imagined while he was building it, purely out of professional discipline, never once suspecting it would someday need to protect his legacy from his own brother. I think often about Anders's notebooks, still sitting in those same boxes, page after page of dated patient documentation of a problem he cared about enough to spend 3 years working through methodically, failure after failure, until he finally got it right. I think about how easily this entire betrayal could have gone undetected if he hadn't been quite so careful a documentarian, if I hadn't happened to search his name online out of nothing more than grief-driven curiosity 4 months after he died, if Odalie hadn't remembered his own descriptions of the project clearly enough to corroborate what the notebooks already showed. I think about how much of what actually protected his legacy came down to habits he'd built for entirely unrelated reasons. The careful engineer's instinct to document everything, just in case. A habit that turned out, in the end, to matter more than either of us could have imagined, while he was still alive to keep building it.